The Supreme Court sentencing order that provided no jail to the Ansals for their role and their conviction of death by criminal negligence in the Uphaar tragedy. The details of that sentencing order are out. It says appellants are fairly aged, not fruitful to send them for rigorous imprisonment. The appropriate sentence has to consider the gravity of the offence and the age of the accused. The sentence should neither be excessively harsh nor ridiculously low. Aware that a matter of this magnitude may call for a higher sentence, but the court had to limit itself to the choice available under the law. While we've talked extensively about them getting off any jail time, this justification that they are too old to go to jail is something that I think people are reacting to. We're going to discuss that. We have in the studio with us Neelam Krishnamurthy, who's fought extremely hard for justice for the Uphaar victims. Also in the studio, former Supreme Court Judge Justice Sudha Mishra, and from his residence, the former Attorney General of India, Soli Sorabji, joining us as well. Neelam Krishnamurthy, I actually want to start by asking you, we've already seen, the way all of you reacted when we were told that the Ansals were not going to be getting any jail time. But the fact that they're not getting it because they're past a certain age?
I think I was very shocked. But is that, if age is the criteria, what the Supreme Court has said, that we have to look at the age. One, it's sending a very wrong message in the society, and probably the other people who are litigants and who are waiting, they'll probably got a very good gift in the case of in the way of a Uphaar verdict, that they can actually continue to delay the proceeding, and by the end of it they can all just get away because they're old. So, because what the courts had to see also was, why was the matter, why has it become so old? Sushil Ansal and Gopal Ansal were in their 50s and 40s when the incident happened.
Right.
So, in the Juvenile Justice Act, you see, if a child is committed a crime at the age of 16, even if he is 30, he gets that benefit that you committed this crime when you were a juvenile. So, why should Ansals be getting this benefit, especially when the courts are well aware that the entire trial was delayed intentionally and purposely by Ansals. They had orchestrated the entire thing, the lawyers, because they knew by the end of the day they can say it's been a prolonged trial, we are old and we'll get the benefit. We have the best legal team in India.
But is that precedence, Soli Sorabji, if you could come in on this, is there a precedence for not giving tough sentencing because somebody convicted is past a certain age?
Well, I think age by itself has no meaning. A man may be even 85 years old, as I am, and be quite fit. Question is he of that age? Is he decrepit? Is he suffering from serious terminal illness, which makes it quite likely they won't live any longer? Then you must think of that. But age by itself is meaningless.
Okay, age by
and
itself.
Another thing,
yeah.
Frankly,
yes.
Another thing, you must look at it in conjunction with the gravity of the crime.
Yeah.
I don't know of any case where age by itself has resulted in reduction of sentence, or saying the person won't really undergo the remaining part of the sentence.
Ironically,
I find that rather strange.
Ironically, Justice Mishra, this order also says that the court is aware that a matter of this magnitude may call for a higher sentence. In fact, you were one of the judges who were keen to push for a high sentence, the maximum sentence possible for this crime.
So, of course, I have been expressing myself regarding the maximum punishment. Unfortunately, under 304A, the maximum punishment is 2 years or fine or maximum sentence along with fine.
Yeah.
So, first of all, this fine which has been imposed, this is not really a compensation.
No.
This is a fine imposed on the accused persons.
Right.
But let me tell you, this is so far as the sentence is concerned, the statute puts a maximum and a minimum punishment in regard to all offences. So, like for instance, in a 302 matter, in a case of murder, the judges will not have a discretion that because this accused is 80 years old, so they don't go to jail. They will have to either life sentence or to the gallows.
Right.
So, the choice is only between the two. So, but there are other offences, well, like 304A. Unfortunately, we don't have any provision where there should be adequate punishment for man-made disaster. This, I think, ought to be included under the IPC. That is not there. So, unfortunately, this offence had to be tried under section 304 capital A, where somebody commits an offence unintentionally, like driving. If you commit an offence, so driving on the road recklessly and creating a disaster of this nature are all tried in a one offence. So, that is the limitation where the punishment is maximum 2 years. Now, speaking for myself, I strongly felt that High Court should not have reduced the sentence of 1 year, 2 years, which was awarded by the into 1 year. And but as they there's a saying in Sanskrit, Munde Munde Matir Bhinna, means every mind has a reason of its own, and more so in the judiciary and especially with the judges. We have the two judges, we have not agreed on the higher sentence of 2 years. So, but here I want to make, I want to highlight, because this is being missed. In earlier also I had said that in this, so far as 1 year sentence is concerned, the High Court had awarded reduced from 2 years to 1 year, and the two judges, myself and Justice Thakur, who had earlier decided the appeal, we had dismissed the appeals of Gopal Ansal and Sushil Ansal so far as 2 years, 1 year sentence is concerned. And out of that 1 year, we have already given a direction that they should surrender for the remaining part of the sentence. We had no disagreement on that part. So, the disagreement was only in regard to the higher punishment as to whether it should be enhanced from 1 year to 2 years.
2 years,
So, let me just complete. So, out of that 1 year, they have not served the entire 1 year.
Entire 1 year either. That's
they have one of them have served, the elder brother has served for 5 months.
6 months.
The younger one for 4 months. So, if the appeal was dismissed, I was even like a litigant, I felt that they ought to surrender, and then they should, the argument should be advanced before the larger bench, whether 2 year sentence should be there,
or not. All right, Neelam Krishnamurthy, you want to come in on this?
I want to say, when the Supreme Court said they should see the gravity of the offence, I only want to tell them there are 59 people dead, out of them 23 children, the youngest being a 1-month-old child. They see the manner of commission, it was done only to increase the profits. I want to understand, why should our children pay with their lives? Because Ansals want to make some extra money for their great grandchildren. The age of the accused and the other mitigating and aggravating factors. The court has failed to take note of this, that Ansals had tampered with the judicial records and they are facing a trial. Am I to understand by this verdict of the Supreme Court that if Ansals are ever convicted for tampering with evidence, which the Supreme Court, while cancelling the bail in 2008, had said, tampering with evidence is more heinous crime than committing a murder or dacoity. This was Justice B.N. Agarwal who said that, and he cancelled their bail. So, am I to understand, tomorrow if they are convicted, will the trial court let them go scot free because they are old, or will they ask them to pay another 50 crore, or maybe by the time another 100 crore? Is that the precedent that is being set? Am I to follow this case now, or should I leave it?
Solely, Swaraj, that's an interesting question, because legal precedent is something that lawyers quote time and again when it comes to defending their cases in court. Is this a precedent that's going to actually be set in motion, and what does it mean for all of us going forward?
Well, actually, I believe that the suffering of the victims, the family members of the victims, the trauma they suffered, cannot be really measured or evaluated in monetary terms. That's my basic objection to this. And of course, people will use it as a precedent. The message will go that if there are rich and powerful people who can engage eminent counsel, they obtain relief, which people of modest means cannot. Now, the fact of the matter is, this has been a conviction. The Supreme Court said if the second gate was not opened, there would be less people who would have died or been injured. Now, having regard to that, I don't understand where is the question of any leniency in the matter. And another thing I don't understand is Sushil and Gopal, principle of parity. What parity? They are not of the same age. And principle of parity was argued by Manani, and the court repeats it without explaining what is the principle of parity.
The parity should be with the other accused. The other accused, the DBB guy and the gatekeeper has been made to undergo 2 years. 2 years. Why Ansals are being made to go? The parity should be with the other accused.
In fact, if you read my judgment, there I have dealt that there is no, so far as parity is concerned, Sushil Ansal was, he was a licensee and was not actively managing, but Gopal was actively managing, so that could have been inferred that there is no parity as such even if you go on
Even
the
if
fact.
you go-
Agreed.
Yes, Mr. Sarabji.
No, the main thing is, what is the message?
That's, I think,
Which goes out.
that's the question we're all asking. What is the message from something like this?
That's something which bothers me. And I think the judgment, of course, judges are well-meaning, no question about it. But I'm sorry to say, with due respect, it does more credit to the heart than to the head.
Okay, fair point.
The only thing I like to say this, that I thought this judgment will bring in some deterrence, will bring some safety culture in our country, and I think I failed, because this is sending a strong message
Ms.
to the
Krishnamurthy,
society.
you haven't failed. I think what you've done is just make sure that all of us are much more aware. I mean, I think that one can't take away from you and your struggle over all these years. But thank you all. We have no more time on this discussion. Thank you all for joining us.